Hi, um, I'm Howard Elgot, Parklane Plowden Chambers. I'm going to give a talk on consent to treatment, and I've called it a practical guide to how lawyers can make a difference. What I'm going to do is just wait for another couple of minutes to see who else is going to join us. We've got quite a lot of people who've joined us already. But it's 12:33 and people are still joining at this time. And so if you don't mind, I'll just give it another minute or so, so everybody can hear it all. I had hoped that I'd be able to see you all, but unfortunately, the way we've got the technology set up today, that's not possible. But I hope you can see me, and but more importantly, I hope you can hear me. Okay, well, as the number of attendees has stopped going up, let me start. Consent to treatment is very important as a topic for lawyers to understand, because it's an area where lawyers can probably make the biggest difference when it comes to seeing whether there's a cause of action. I'm going to hopefully you've all got the slides which you can follow, and I'm going to follow the order of the slides. Those of you who've got the slides can see that the talk is divided into 4 parts. There's the introduction, firstly. Then there's the GMC medical guidance. Then there's a review of the law, and then there's a part of the talk is about the role of the lawyer. As I think you probably all know, consent claims differ from ordinary clinical negligence claims because it's not necessary to prove that the doctor was bold and negligent. That stems from the case in the Supreme Court called Montgomery and the Lanarkshire Health Board. And so the role of the expert medical witness in a consent case is less important than the role of an expert medical witness in an ordinary case. And the role of the lawyer is more important than the role of the role of a lawyer in an ordinary case. So it's necessary to look at consent, firstly from the viewpoint of the doctor, because the basis of what a doctor should do and not do is as much set by the General Medical Council as by the law. And the General Medical Council have issued recent guidance, updating their previous guidance, in a booklet called Decision Making and Consent. And the slides show the General Medical Council booklet, the front page. It's an extraordinary large booklet. It runs to 44 pages, and in the slides and handout, you'll be able to click through to the actual booklet and see it on the internet. And in the introduction, it says this on page 4: consent is a fundamental legal and ethical principle. All patients have the right to be involved in decisions about their treatment and care, and to make informed decisions if they can. The exchange of information between doctor and patient is essential to good decision-making. Serious harm can result if patients are not listened to, or if they're not given the information they need and time and support to understand it, so they can make informed decisions about their care. Now, there then follows something that every lawyer really needs to read. And on page 9, it says this, that the 7 principles of decision-making and consent. Principle 1, all patients have the right to be involved in decisions about their treatment and care, and to be supported and to make informed decisions if they're able. So it's the right to be involved, the right to be supported in order to make the informed decisions if they're able. And so note, this really goes a lot further than signing a consent form. Principle 2, decision-making is an ongoing process focused on meaningful dialogue, the exchange of relevant information specific to the individual patient. So it's not one size fits all. It's the exchange of relevant information that is patient specific. Principle 3, the patients have the right to be listened to and to be given the information that they need to make a decision and the time and support they need to understand it. So it's not merely the support, it's time and support they need to understand it. Principle 4, doctors must try and find out what matters to patients. So the onus then is on the doctor is to find out what matters to the patient. And the reason given in principle 4 is so they can share relevant information about the benefits and harms of proposed options and reasonable alternatives, including the option to take no action. So it's proposed options, reasonable alternatives, including the option to do nothing. Principles 5, 6, and 7 relate to patients who don't have capacity. And in effect, are likely to be less important in practice when dealing with consent cases, I suspect. Principle 5 is that doctors must start from the presumption that all adult patients have capacity to make decisions about their treatment and care. A patient can only be judged to lack capacity to make a specific decision at a specific time, and only after assessment in line with with legal requirements. I mean, as it happens, I'm currently working on a case where one of the issues in the case is whether the claimant has capacity. And there's a lot of mention about the presumption of capacity in the case. And I think rather too much is made by doctors about the presumption of capacity. Because as lawyers know, presumptions in most areas of the law relate to issues where there is no evidence one way or the other, and it doesn't take very much evidence to move from a presumption to the ability to make a judgment on one side the other. And you often see doctors in this context saying that there is no evidence to move from a presumption of capacity, when there is in fact shed loads of evidence. It might be evidence which is to be weighed into the balance in favor of capacity, and if so, the presumption is not dislodged. But doctors, I think, sometimes get this wrong, and therefore assume that there's capacity when there isn't. Anyway, that's principle 5. Principle 6 says this: the choice of treatment or care for patients who lack capacity must be of overall benefit to them, and decisions should be made in consultation with those who are close to them or advocating for them. In practice, I don't think that happens. Particularly in the care of the elderly, from what I've seen, and decisions tend not to be made in consultation with those who are close to them or advocating for them, in my experience. Anyway, the GMC says that it should be done. 7. Patients whose right to consent is affected by law should be supported to be involved in the decision-making process and to exercise choice if possible. I think that's a reference to people who've been sectioned. And whether they are supported to be involved in the decision-making process and exercise choice if possible is at best an interesting question. The next part of the GMC guidance, I had the information you give patients, so that's the GMC heading. You must, so that's must, it's not optional, you must give patients the information they want or need to make a decision. This will usually include A, diagnosis and prognosis, B, uncertainties about the diagnosis or prognosis, including options for further investigation, C, options for treating or managing the condition, including the option to take no action, D, the nature of each option, what would be involved in the desired outcome, and E, the potential benefits, risks of harm, uncertainties about, and likelihood of success for each option, including the option to take no action. So paragraph 10 of the guidance is very important indeed to lawyers, because it deals with so many categories of information, all of which come together to make for an informed consent. Diagnosis, prognosis, uncertainties, option for further investigation, options to take no action, the nature of each option, potential benefits, risks, uncertainties, and likelihood of success. And a lawyer needs to know about the existence of what is contained in this GMC document, because without knowledge of this, it's not possible for the lawyer to properly analyze whether there is a consent claim or not in the case before you. So that's where we are from the doctor's side. And that's where we also need to have the knowledge on the lawyer's side. So let me move from the GMC guidance to a review of the law. And first principles really come from Montgomery and the Lanarkshire Health Board, GMC intervening, 2015 appeal cases 1430. And in the handout, you'll see that there's a picture of Nadine Montgomery and a quote from her. "Out of our own tragedy, we find our life's purpose." And Nadine Montgomery is an ambassador for the charity Baby Lifeline, which exists to give support to medical professionals involved in childbirth, and it's a very important charity. I've got no doubt at all that Nadine Montgomery would wish to be named and identified as the claimant in this case. And she certainly doesn't want anonymity. So just a quick review of the case of Montgomery. So Nadine Montgomery was regarded as having a high-risk pregnancy because she was diabetic and of small stature. When told she was having a larger than usual baby, she raised concerns about vaginal delivery. But the doctor did not tell her that diabetic women had a 9 to 10% risk during a vaginal delivery of shoulder dystocia in the baby, where the baby's shoulders were unable to pass through the pelvis, as in the doctor's view, the risk of a grave problem resulting for the baby was very small, in the doctor's view. And if the condition were mentioned, the doctor said, most women would ask for a caesarean section, which, the doctor said, was not in their interest. This did not go down well with the Supreme Court. And the Supreme Court held that a patient was entitled to decide which, if any, of the available forms of medical treatment to undergo, and a consent had to be obtained before treatment interfering with her bodily integrity was undertaken. And as I'll go into the principles from Montgomery in a bit more detail, but it's worth noticing that there is really no difference between what the Supreme Court said in Montgomery and what the GMC guidelines in the booklet that was extant at the time of Montgomery and in the 2020 booklet actually say. So the Supreme Court went on to say this: the doctor was under a duty to take reasonable care to ensure the patient was aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. And so the material risk part of it is well known. Perhaps the reasonable alternative or variant treatments part of it is less well known, but it's there in Montgomery. It's also in the GMC guidance. And so the test of materiality isn't in the GMC guidance. The Supreme Court said this: the test of materiality was whether, in the circumstances of the particular case, a reasonable person in the patient's position will be likely to attach significance to the risk. So that's where reasonableness comes in. Would the reasonable person be likely to attach significance to the risk? Or, alternatively, was the doctor, or should the doctor have reasonably been aware that the particular patient will be likely to attach significance to it? So there's both objective and subjective components to the test of materiality. The reasonable person would attach significance to the risk. You've got to mention it. the particular patient would be likely to attach significance to the risk, you've got to mention it. And the only exemption from this, said the Supreme Court, was the doctor was entitled to withhold information as to risk if he or she was reasonably considered that its disclosure would be seriously detrimental to the patient's health or in circumstances of necessity. It's quite difficult to find examples of withholding on the basis of serious detriment to the patient's health. I mean, I've certainly never come across that in practice. Circumstances of necessity are pretty obvious. I mean, if the patient's unconscious, you can't consent them. Now, as Ms. Montgomery would not have consented to a vaginal birth had she been properly consented, she was entitled to judgment. So that's your causation point. So obviously you've got to prove that had the person been given the proper information, the client, patient, would not have consented. Now, that's refined for consent cases in a way that causation isn't refined for other cases. And that brings us to the case of Chester and Afshar, a case which predated Montgomery. In 2005, one appeal cases 134. So in Chester and Afshar, the defendant failed to warn the claimant of a 1.2% risk that the patient might suffer cauda equina syndrome in what was an elective operation. So that's important. There's obviously a difference in whether you can prove consent and prove causation if the operation is elective or if the operation is one that really the patient has to have. And Chester and Afshar was an elective operation. The findings of fact were, had the risk been brought to the claimant's attention, she would not have undergone the surgery at that time. And on the slides I've put at that time in red, because that was the pivotal phrase that allowed the claimant to win in that case. So she wouldn't have undergone the surgery at that time, but she would have sought advice on alternatives to surgery. And so the really important point is that she didn't prove that she would never have undergone the particular surgical procedure. And the defendant argued that this was fatal to her claim. But the majority of the House of Lords, because this was just before the Supreme Court came into being, accepted the defendant's failure to warn neither affected the risk, nor was the effective cause of the injury. So the claimant couldn't satisfy the conventional test of causation. So the defendant said, aha, the defendant loses, the claimant loses. But the duty to warn, said the House of Lords, was central to her right to make an informed choice. In the light of these considerations, justice required a modification of traditional causation principles to vindicate the claimant's right of choice and provide a remedy for the breach. So in consent cases, what the claimant has to prove is not that she wouldn't have undergone the procedure in the future ever, merely that she wouldn't have undergone the procedure at that moment in time with the surgeon who caused the damage, even though the damage was an ordinary risk of the surgery and wasn't negligently caused damage. So there's a big advantage of a consent claim when it comes to looking at causation. So the role of the lawyer. I dare say that most of the people, and I obviously I've got a list of the attendees, and I guess that most of the people here are well familiar with the different types of consent, that consent forms, notes, etc. that you need to look at. There are loads of examples of consent forms on the internet and on the handout that you'll be able to click through to a consent form relating to a pediatric or orthopedic operation. But nowadays there are more and more consent booklets. So there's not only consent forms like there used to be in the good old days, but now there are consent booklets. The one that you can click through on the slides relates to consent to a cesarean section from an English hospital. But of course, as we've all seen, there are often notes in the hospital records relating to the consenting procedure. So they've got to be looked for. But finally, and it's obviously more difficult, is where it's suggested there's been oral consent, which has been unnoted. Now, on the one hand, it's harder for a defendant doctor to show that there was proper consent if the consent is unnoted. But on the other hand, it doesn't make it easy either in relation to your own client, because it's true to say that that patients often don't remember the full content of any discussion about anything with a doctor. So, on a practical basis, do we want to run claimant cases on a CFA if they're just consent cases? Really, this is something I think we can talk about more when I finish. I'll do another quarter of an hour, and then we can, then hopefully we can have a chat. And by the way, that at the bottom of your screens, there's a Q&A button. I can see. I can see that some of you are already looking at this button, but I think it's particularly seeing as I can't see you at the moment. Can I invite you to ask questions on the C&A button? And also there's you can also raise a hand as well via Zoom, but you have to go down to the bottom of the screen and hit the 3-dot button, and you get the various options. So somebody comes to you and says, oh, I've suffered an injury, but I don't think I was properly consented. Is this a case that you want to take on a CFA? I mean, my guess is that not many of those cases who might come in through the door would be worth taking, because the consent tech cases that are worth taking are probably consent cases where the claimant doesn't even know they haven't been consented properly. I mean, this is often the case in obstetric cases. So these ordinary consent claims are quite high risk, I think, if that's all we've got. So the kind of consent case I think you want is one where there's prima facie negligence as well, and consent is a second string to your bow, because you've got the causation problems, haven't you, that most doctors will take their doctor's advice, and it's sometimes difficult to persuade a court that they wouldn't have done. There's the issue I mentioned before. Do patients remember everything they're told when they're consented? Defendants always argue that a claimant's guilty of ex post facto rationalisation. Judges are suspicious they might be, and so these claims are high risk. But it's the lawyer that needs to be alert for consent issues, because in my experience, medical experts often miss consent points in their reports. They might lead a little persuasion in a conference, maybe. They might need a lot of persuasion. Because the great advantage that you will have if you are conversant, which is what is in the GMC guidance, is that you will know what's in the GMC guidance when the doctor doesn't, when the expert doesn't. And so, because although it's mandatory for doctors to know the mandatory requirements of what is in the consent booklet, it's absolutely mandatory, and there could be disciplinary proceedings taken if they don't. The truth is that your expert witness, who is a wonderful orthopedic surgeon or a fantastic neurologist, is not that hot on what is contained in the guidance in relation to consent coming from the General Medical Council. And so somebody in a case has got to know it, and that really has got to be the lawyer. And so you will get the sort of, if you like, the bog standard consent case, which is probably where probably involving a obstetric practice, where the obstetrician will simply miss the consent point in relation to cesarean, or often cesarean not being offered at the right time, instrumental deliveries, and so on and so forth, and it's your job to ask the expert, well, do you think that the patient was probably consented, and suggest that having read the notes, that there doesn't seem to have been compliance with good practice. And my experience is the obstetricians say, yes, of course that's right. Of course they should have been consented. And you think, well, why didn't you put it in your in your report? And in my experience, clients again would not raise the point either. It's consent is an issue of law, and it's something that has got to be understood by lawyers, and the point has often got to be raised by lawyers. Okay, let me give you an example in the law reports of a successful case. A case called Birch and University College, 104 BMLR 168, a decision of Mr. Justice Cranston. The claimant suffered a stroke after undergoing catheter angiography. Unfortunately, a responsible body of medical opinions endorsed the use of catheter angiography for the claimant. But Ms. Birch had entered a neurosurgical rather than a neurology ward under a recommendation she undergo MRI, and would have selected the option of undergoing the less invasive MRI had she been properly appraised of the comparative risks. And so the trust's failure to discuss the implications of the various imaging methods and the comparative risks rendered the trust liable. So offering just one of two reasonable alternatives was simply insufficient. And when the serious risk materialized, and Ms. Birch had a stroke, there was liability without negligence. Birch was mentioned in Montgomery without criticism. It predated Birch, and it was referred to also by Lord Justice Rafferty in the Court of Appeal in Micklejohn, but which was a somewhat different case. I don't propose to refer to any cases later than Montgomery, because you won't be surprised to hear they all turn on their own facts, and there are no new points of principle following Montgomery. Trust me, I've read them. They're not really worth reading unless you're a defendant, because some pretty grim cases from the claimant point of view have been taken to court since Montgomery, and perhaps unsurprisingly they didn't succeed. Let me give you some examples from my own practice. I've been involved in many cases where mothers are still not being offered caesarean sections appropriately. But these cases invariably succeed on behalf of the claimant. At the very least, they settle at JSMs or whatever. I mean, I've never had to fight one. I mean, other examples. I had two or three cases, but not recently, which all had a similar kind of theme to them. The patient's leg had been amputated in a small regional hospital. Instead of the surgeon referring the patient to a tertiary referral centre, where there were more skilled vascular surgeons. I did one in the Midlands, I did one in Yorkshire, I did one in the Northeast, and amazingly enough, the one in the Northeast only settled at the court door. There aren't very many court door settlements nowadays in clinical negligence case, but that one did. And they're all cases where which, never mind whether there was negligence or not, in none of these cases had the patient being given the option of being treated at a tertiary referral centre. and that's criminal, really. Anyway, they all succeeded. A more, if you like, bog standard case I had, although the facts weren't bog standard at all, was I acted for an Italian footballer who was a professional footballer, having recently been signed from Serie A in Italy, and he had the misfortune to suffer what's known as a sports hernia, and he was sent down by his club to a surgeon who had performed 27 similar sports hernia operations on players at that particular club, we found out. Now, the problem with my client, and the problem with the surgeon in this case, is that neither spoke each other's language. As the surgeon was seen to comment in the notes after everything had gone wrong. And so there was no attempt by the surgeon to consider whether his English was good enough for the footballer to be consented without an interpreter. And so the footballer said he thought that that all that was going to happen was that the surgeon was going to examine him under anaesthetic, not perform the operation. And as he said, and I think was true, that there's absolutely no way he would have undergone an operation without discussing it with his wife first. Secondly, there was no way he would have allowed an English surgeon to operate on him, because like all Italian footballers, apparently this is true as well, they like to be operated on in Italy. And what's more, he'd had a similar problem on the other side, and wanted to go back to the surgeon who had successfully performed the operation on the other side. Anyway, that's settled on, not far from trial, but in effect on the basis of full admission. And as most recently, I was involved in another fairly straightforward consent case, where a producer of TV commercials who got something called surfer's ear, not a condition I'd ever heard of before, but he was not only a producer of TV commercials, but he was a very keen surfer, and he'd moved to Cornwall to be able to do even more surfing. Got this surfer's ear, which was affecting his hearing, and made it rather difficult for him to be on sets. And he had a promise by the consultant, who was the leading expert, apparently, so he said, that he'd perform the operation himself. And amazingly enough, the defendants agreed that he'd had that promise, and the operation was carried out by somebody else. And so we didn't really need to bother much with the negligent part, although it was carried out negligently, because the consent was a slam dunk. He'd been promised Mr. So-and-so, and he got Mr. somebody else. So there is a lot of consent stuff about, but I think you have to look for it. So, all right, I said I'd do 3/4 of an hour, which, and I think I've been true to my word. And so should we start the questions, the questions and answers? I see that Elizabeth Hodgson has asked the question that I'm not sure whether we meant to be looking at slides now. I mean, I hope you have. I hope you have. They ought to have been sent out to you this morning. If you haven't, it doesn't really matter, provided you've been listening, of course, because there's nothing much in the slides that I haven't said. But I think it's important to have the slides and to keep the slides, because if you're like me, you're better at assimilating information that's written down rather than spoken. You've got them as an aide memoir. But what's really important, I think, is that if you think there might be a consent case, you can look at some of those slides where I've set out the kind of things that you ought to be looking for, and quoting word for word from the GMC guidance. Now I've got a question from somebody who is called PS2. So I don't actually know who PS2 is. Loads of people have got names. So hi PS2. Whether it's somebody that I know or not. Says, could you comment on the role of medical experts in consent issues? I keep coming across cases where judges have quoted evidence from medical experts on what advice a responsible body would have given, which appears to be Boland coming in via the back door. Yeah, I mean, this is absolutely what happens. I mean, Boland can't come in via the back door. It just can't, because Boland doesn't apply directly to consent issues. Just like it didn't in Montgomery. But you've got to be really clear in your own mind what is a consent issue and what isn't a consent issue. So, for instance, let me give you another example from a case that I've got that I didn't give before. I'm involved in a case where my client had acne, and there is a very good treatment for acne, which has however, it has lots of side effects. And what is the worst side effect that you could have? Oh, hi, Paul, by the way. Paul Sankey, thanks for the question. What the worst side effect is that it causes pretty horrendous fetal malformations, and so I've got a case like that. There are very strict rules about the prescription and guidance given by the British Association of Dermatologists about what to do and what not to do. And we could have a whole hour's discussion on this. I'm not completely convinced that the guidance from the British Association of Dermatologists is wholly Montgomery and GMC compliant. And so we may end up, the case has not been pleaded yet, we may end up in a situation where the dermatologist has followed appropriate guidance given by the British Association of Dermatologists, but that guidance was insufficient to be Montgomery compliant. I think it's quite an interesting case. And it's fair to say that there's no point in a claimant having an expert in that case who doesn't understand the difference between Bolam and Montgomery. And so I mean, hopefully the expert that we have is fairly enthusiastic about the case. It seems that she is, and I think she does understand that difference. But I mean, it just shows you that you have to know this law so well. You have to be so conversant with what is consent and what is negligence. And undoubtedly, if a dermatologist follows the guidance of the British Association of Dermatologists to the letter, it might be quite difficult showing that they're blithe or unreasonable, but it might be easier to prove that you've got a Montgomery case. So I hope that answers the question. Paul, if it doesn't answer the question, can you just answer more? Can you just come back to me in writing through Q&A and say yes, but and say thanks for your answer, but what about this? And I'd be grateful. Let's see what else we have. So Paul has actually said, Paul, I hope you don't mind if I just read this out now. My answer is they can advise on the treatment options and risk of each, but not which should be discussed with this particular patient, which is not a matter of medical expertise. And I'm sorry, I misread that. And a matter for the court. Well, that's absolutely true. Because they've got to somehow find out what is significant to the particular patient. And of course, what an expert can say is, well, it's true that there were two alternatives, but alternative A, I've advised you should do. Alternative B, that you're saying I should have advised on, is not a reasonable alternative. And so that's something which a doctor is able to say, but it's not quite Bolam. The doctor can say, well, I didn't advise that about this particular alternative because I didn't think it was a reasonable alternative. And that's a matter of fact, whether it was a reasonable alternative or not. But it's not quite Bolam. It's reasonableness, but in a different context. And yeah, I mean, obviously the problem is, and I've had this problem as well, is that you can have an expert witness who just doesn't understand it, who just doesn't understand what content is, and he's been on some training course, for an expert witness training course, and he thinks he knows it, but they've kind of missed out consent or whatever, and it doesn't matter, and it can be difficult. But it's really important, and I keep banging on about this, that the lawyer knows, that the lawyer holds his or her ground if they're right. I mean, if necessary, you can bring out the GMC guidance in the conference, although nowadays, seeing as we seem to be having conferences by Zoom or whatever, it can be harder, but at least you can read it out. But you know, be sure of your ground, because in a big case, consent can often be the difference between getting an early admission or not. You know, hit them with both barrels, hit them with the negligence, and hit them with consent, because two barrels are always better than one. Okay. Thanks, Paul. I mean, I hope that answers that. All right. Any more for any more, or are we all going to get back to our to our sandwiches, which I haven't quite made my own yet. So yeah, I mean, there are times for any questions. I see from the people who are who are attending that there's loads of people who've got loads of questions, who could easily have loads of questions. But okay, I don't know if you can unmute yourself. I don't think you can, which is a bit of a shame, because you can always shout out as well if you could. But I don't think the way we've got it set up, you can. Okay, all right. As we've more or less reached 1:30, I think probably time's up anyway. Thanks to everybody who has come. If there's anybody who for some reason hasn't received the slides in the handout and would like them, can you get in touch with me on my clerks? And they will be sent to you straight away. Yeah, thanks for listening to me on what is a particularly interesting topic as far as I'm concerned. All right, thanks very much. Bye.